Bill Morgan has made it clear to the public that the court's decision about XRP sales does make XRP a security. Ripple is now in court battle with the Securities and Exchange Commission, and something unexpected has happened in this fight. There is now a heated argument on Twitter because a famous lawyer and crypto fanatic named Bill Morgan has joined the debate. Through Morgan's thinking, there has been a major misunderstanding. But what exactly does Morgan have a problem with? In reaction to what Stark said, you should read more if you want to find out more about Morgan's ideas and how they might affect the cryptocurrency market as a whole. Morgan learned about the claims made by John Reed Stark, who used to be head of the Securities and Exchange Commission. This made the conversation more heated. Stark made the case that the judge in charge of the Coinbase case actually didn't agree with Judge Torres' finding, which argued that buying and selling unregistered securities or investment contracts could be thought of as secondary transactions of XRP. There was something the judge said that I respectfully disagree with, and I knew it would be brought up. Yes, I do agree that it is a reasonable concern in many ways. Before we go any further, let me show you the Neptune token. You can use the TronLink wallet to trade it for USDT at any time. Sign up for the Neptune app and bind an invitation code to get a free Neptune ticket. I've used it and it worked for everything I'm telling you here. Get the Neptune app and free Neptune tokens by clicking on the link in the description below. You can then trade these tokens for USDT whenever you want. Check out our other video on this subject for more help if you get stuck. In the next sentence, there is a link to the movie. Torres quickly made it clear that the issue of private sales had not been properly brought to the court's attention. He made it clear that he hadn't said anything like that about the sales of XRP on the secondary market, which made him wonder what Fila was arguing about. Morgan didn't believe Stark's claim and told him it was false. He had written down that he hadn't said anything like that. Mark Fagel, a lawyer, questioned Morgan's stance to make the argument more heated. Fagel said he wasn't sure if token sales through platforms would be able to meet the high Howey level set by the conservatives. Morgan did not argue with Fagel's opinion, but he did say that he did not agree with it. Morgan said that Torres' main focus in his research is on Ripple's programmatic trades, which is a subset that the SEC chose. He emphasized Torres' finding that these programmatic sales did not meet the requirements for an investment contract. He also praised Torres' ability to think things through. It was brought to his attention how determined Torres was. Morgan went on to say that even though Torres agreed with Ripple's plan to market XRP to institutional buyers, there wasn't any strong proof of general dispersion that he could find. Morgan said what he did in answer to a coworker's question. As an example to make his point, he used the Solana coin to show that the O-test is more complicated than it seems. He said that these kinds of findings can't be applied to other cryptocurrencies without being unfair. Morgan says that Torres' decision on programmatic XRP sales means that no secondary market coin sales can ever be considered investment contracts. Morgan made a case against this idea. He made sure to stress that the test was fact-based, and he confirmed that the conservatives' results do not always rule out the possibility in every situation. Based on the extensive study that Torres did, Morgan decided that Torres' conclusions were based on facts that were not in question. Because of this, it became less likely that the SEC's case would be successful. Based on his professional opinion, he thought it was very unlikely that the SEC would be able to successfully appeal the ruling. In July 2023, the decision in question was made. It was seen as a major turning point in the field of cryptocurrencies. When traded on the secondary market, XRP was seen as a non-security. On the other hand, recent events have made people question this choice, which has led to questions about how XRP is regulated. At the moment, federal courts are re-examining whether certain legal rules should apply. This makes Ripple and its investors nervous about the situation. Without a doubt, it's really as bad as it looks. Here is a more in-depth look at what is happening now, which gives a more complete assessment. As a shocking turn of events, 2 federal judges have said they are not sure if classifying XRP as a non-security asset is legal under the Constitution. There is a chance that XRP could be considered an unlisted security because the HO test is being looked at right now. This is one of the most important parts of securities law. A lawyer named Charles Gasparino is not happy with how Judge Analisa Torres interpreted the HOI test. This means that Judge Torres' decision might be overturned. To remind people in the XRP community, 2 federal judges, including the one who is thought to be the dean of corporate law cases that use Judge Torres' decision for Ripple as a model, have been made fun of by the court rock-off. The reason for this is that federal courts are currently looking into Ripple and are looking at the HOI test, which is a key part of figuring out if an asset is a security or not. No one can promise that the finding will be used because it makes no sense. The chance that XRP could be put into real-world categories. There is something that would be bad for Ripple and its stakeholders if this law rule is found to be invalid. XRP supporter Bill Morgan is still not sure about the project even though Gasparino has raised the alarm. The claims made by Gasparino are called into question by Morgan, who wants real proof of court criticism. Even though there are many regulatory problems, big holders of XRP, who are known as whales in the business, are still buying it, which shows that people are sure about how the price of the cryptocurrency will change in the future. XRP's price, on the other hand, has been stuck in a range for more than a year, which has tested buyers' patience. It doesn't seem to bother Morgan that Gasparino has raised the alarm. He is still skeptical. Examining the costs involved, the price of XRP is currently hovering above the important 60 cents line. There are positive signs that a possible recovery may be on the horizon, though it will depend on the market as a whole. Analysts expect a recovery towards the year's high point of 74 cents. On the other hand, there is a good chance of a negative risk, which includes the chance that the price will fall below important support levels. This shows how vulnerable the market is to bad things happening. Aside from legal issues, the road ahead for XRP is still full of problems, even though many people are still hoping for the price to rise again. An idea was put forward that asked Ripple to give most of the tokens that are currently in escrow to the XRP Ledger Foundation so that the XRP community could use them. The plan was answered by David Schwartz, who is the Chief Technology Officer of Ripple. To be more specific, the idea came from Panos Medicis, who is a co-founder of Anotis Finance. He thinks that the XRP coins that are locked up in Ripple's trust would be better off with XRPL. Thanks a lot.